said on behalf of our Antitrust and Competition Group, World Law Group, would love to welcome you to our conference call, a video, new way of meeting and resuming conversations and discussions on antitrust. Our idea is to make this not only about reconnecting, but also discussing substantive topics so that we can make it useful for us. And there are lots of things happening in the antitrust world that we believe will be of relevance and interest to everyone. Just for those who are joining in now, in Harald Kallenberg from Siemens, Hasche Ziegler in Germany is the chair of the group. Scott, you and from Zhong in China, and myself from Tosini Freire in Brazil are the co-chairs. And besides the meetings and meeting in person, which obviously is for few people in the semi-annual World Law Group conferences, we want to make this means of communication more and more active and more useful to us, to everyone. So obviously we'll welcome also comments and suggestions for topics and also formats as we go along. Please, this is supposed to be an interactive conversation later on, so please feel free to jump in, talk, bring contributions. Our agenda for today, first going through the introductions, we'll be touching on two very important recent developments that we've had that took place in Europe, but as I said, will be relevant to people around the world. Court decisions in two of the largest cases the European Commission's ever had, involving Qualcomm and Google, and then discussing what we're seeing as trends happening in other jurisdictions. And then again, we invite you all to bring your comments and contributions. And towards the end, we'll just give you an update on what the group's been doing and some projects that we have, especially concerning the merger control guide, and where we are and where we're going to go next, and also what we will be asking of you all in terms of help soon. Harald, Scott, I don't know if you want to complement or add this point.
Oh, thank you, Marcello. Hello, everyone. Good morning, good afternoon, good evening. Yeah, I think Marcello has already spoken all that we want to say, especially that we encourage everyone trying to speak out. This is more not a presentation, it's more like a forum for all of us to express and exchange useful information so that we can create more synergy among the different teams. So yeah, I just want to stop then to let I don't know, Harald,
yes,
to talk about today's very interesting topic.
Oh, sorry for the noise. The background we have in the background, we moved into the building you can see in my background photo, and Marcello was here in Stuttgart the week before, so he can confirm the building really looks like it, with more than 11,000 plants in 2,000 boxes and 390 meters of fences in form of wood, and then 38 trees on top of the building of up to 10 meters. But the building has not been finished yet. That's why there is that background noise. Now, when we discussed the program for this meeting, we said we don't want to have a presentation and then this official type of thing. And Scott suggested to speak about the Qualcomm decision of the General Court and the Google Android decision, which was made by the General Court last week. I was, well, I said I volunteered to find somebody, asked my partners, was too late, and in the very end had to read the decision myself, which is, however, very welcome to me. So I have to deal with it, and I have to really read it, which is normally quite difficult for me. So the EU competition lawyers may forgive me if I am too short in might talk about these decisions, but I think we shouldn't go into the very technical details. The first very interesting decision of the last months is the judgment of the General Court in the Qualcomm case in June this year. We were also involved in this for a third party. It related to exclusivity payments. The European Commission imposed a fine on Qualcomm in the amount of almost 1 billion euro, more exactly 997.439 million for an infringement which lasted from February 2011 to 2016, and the General Court annulled the decision. It must be nice for a lawyer to get a decision annulled in such an amount, and the European Commission decided already not to appeal this decision to the European Court of Justice. And this decision was on incentive payments under which Apple had to obtain its requirements of LTE chipsets exclusively from Qualcomm. And the court annulled the decision based on a number of procedural irregularities which affected Qualcomm's rights of defense, and also based on an analysis of the anti-competitive effects of the incentive payments. So the first procedural irregularity was that they didn't properly put the file together. There were meetings with two competitors and two customers, and according to the General Court, the European Commission had not properly recorded these meetings, including the precise content of what had been discussed. And that was one of the failures of the European Commission. The second one related to differences between the statement of objections and the infringement decision. In the statement of objections, the European Commission discussed the subject were abuses both on the market for LTE chipsets and then also on the market for UMTS chipsets. And in the final decision, this was changed. It was limited to the LTE chipsets, and the General Court said that as such modification of the objections, the statement of objections, affected the relevance of the data which formed the basis of the economic analysis presented by Qualcomm, the Commission should have given Qualcomm the opportunity to be heard and, if necessary, to adapt its analysis. So this was also not done. In addition, they found errors regarding the question of whether there were anti-competitive effects, and one related to the point that the General Court said, yeah, it's fine with the restriction of competition, but the Commission would have needed to take account of all relevant factual circumstances, one being that Apple for most of the time had no technical alternative to Qualcomm's LTE chipsets. And the second one related to findings that there were restrictions regarding the requirements for certain iPads models to be launched in 2014 and 15, but this would not entitle or would not be sufficient to determine that there was really an anti-competitive effect for all Apple requirements for the whole period of time. So, and then the third issue here in substance was regarding the capability of the Commission to show that there are anti-competitive effects was a lack of consistency of the evidence. I don't want to go too much into details. The case is very important because it shows that the General Court takes the procedural rights of defense very seriously. There were other decisions in the last years in which these issues were raised. The question is, what impact will this have on future procedures of the European Commission regarding Article 102 of the treaty? Most people think that the European Commission has really to revisit its procedures, that it may need to adapt its 2009 guidance. There is a guidance on the Commission's enforcement policy, or enforcement priorities in applying Article 82 of the EC Treaty to abusive exclusionary conduct by dominant undertakings. And secondly, there may be the need for a change of the procedure, looking more into changes between the statement of objections and the final decision. Now, because of these developments, people were also keen to see how the European Court would, the General Court, not the European Court of Justice, would decide on the Commission's decision that Google imposed unlawful restrictions on manufacturers of Android mobile devices and mobile network operators. Here, the original fine of the European Commission was 4.343 billion euro. Quite a nice amount of money, and the General Court came to the result in its decision on the 14th of September, so just last week, and imposed a fine of slightly reduced, still 4.125 billion. Now, this case goes very much in the details of Google's position on the market for search engines, and I don't want to look into all the arguments presented by the General Court, because I think that it's not possible to handle this within a short period of time. It may be interesting to see that there were three types of restrictions. There were distribution agreements, and these required manufacturers of mobile devices to pre-install the general Google search and Chrome browser apps in order to be able to obtain a license from Google to use its App Store, the Play Store. And there were restrictions in anti-fragmentation agreements. Here, the case was the following: the operating licenses necessary for the pre-installation of the Google Search and Play Store apps could be obtained by mobile device manufacturers only if they undertook not to sell devices running versions of the Android operating system which have not been approved by Google. And then there were portfolio-based revenue share agreements under which the grant of a share of Google's advertising revenues were subject to the undertaking of the manufacturers of mobile devices not to pre-install competing general search service on a predefined portfolio of devices. So all very technical. The General Court discussed the various markets, the worldwide market, excluding China, for the licensing of smart mobile device operating systems, the worldwide market, excluding China, for Android app stores, various national markets within the EEA for the provision of general search devices. I don't want to go into all the details. One point in substance I found very interesting, because here the General Court did not follow the European Commission. It followed the European Commission regarding almost everything, but not regarding this sole pre-installation condition included in the portfolio-based revenue share agreements. I mentioned this before. This revenue sharing was subject to the undertaking of the manufacturers of mobile devices not to pre-install a competing general search service on a predefined portfolio of devices. And here, the General Court discussed the question of whether there could be an exclusive abusive behavior. And they said, yeah, there are two elements. The coverage of the contested practice has to be examined, and then it has to apply the as efficient competitor test. And here the Commission came to the result, the General Court came to the result that the Commission did this statement, considered this statement unsupported by the evidence which the Commission set out in the contested decision. So this shows that the General Court really looks into the details and does not simply accept what the Commission does. And then there were two issues regarding the right of defense of the parties. One was the alleged infringement on the right of access to the file. And here again, this related to the record of meetings with competitors, and that they have to be done properly and give the details of what has been discussed, and came to the result that there was a infringement by the European Commission. They did not do this properly, but that according to the case law, a breach of the rights of defense also requires that the undertaking concerned demonstrates that it would have been better able to ensure its defense if there would not have been this error. And came to the result that Google wasn't able to show that this procedural error, not to have proper records of meetings with competitors and customers, that Google would have been in a better position to defend itself. And so that means if Qualcomm was 2 steps forward, Google was at least 1 step backwards. It is not sufficient to show that there is a procedural error. The party, Google, also needed to show that if the procedural error would not have been made, it would have been in a better position to defend itself. And second issue related to the infringement of the right to be heard. That was regarding the complaints of Google regarding the abusive nature of these revenue share agreements, and the challenge that the AEC, the as effective competitor test, has not been applied properly. The issue was that here Google would have been had if the Commission would have given Google the opportunity to be heard regarding this, then they would have been in a better position to defend itself. So here the General Court followed Google's argument, and then as it has unlimited jurisdiction based on all the factors, the General Court came to the result that a fine of 4.125 billion euros would be appropriate. Well, the lawyers of Google were able to reduce the fine at least by about 200 million euro, which is also a nice amount. If you read it and you say, oh, 0.1 billion, that's not much, but it's 200 million euro, and 200 million euro is quite a nice amount of money. These two decisions of the General Court strengthen the right of defense of the parties, and it's interesting that as I said before, the European Commission will not or did not appeal the Qualcomm case, and everybody expects, I think, that they are now reviewing its procedural rules, and we will see how they will do this. Maybe some of you have suggestions how this can be happen, or would like to comment on this, or are in a better position than me to really describe the essence of these cases. So thanks.
You know, I think this is it's so interesting that within a very short period of time, we had two major decisions coming in exact opposite directions. One quashed, and it was a huge defeat for the Commission, and the other one sort of vindicated their original decision. And in a way, I mean, the European Commission is seen by many authorities, certainly by the Brazilians, as maybe an inspiration in terms of its aggressiveness, its readiness to go after large companies in a very firm way. And these are probably the largest fines ever in the history of antitrust that we're talking about here. And the fact that they had such a huge defeat, if they had had another one in sequence, probably would be seen as maybe as a dampening effect on their activity. And the fact that they won, I mean, hearing the commissioner speak a couple of weeks ago, and what she said after this last decision is that they, as Harold said, they will probably change some of their procedural processes, but they likely will continue just as aggressive as before in terms of prosecuting companies. And I said it's an inspiration because some of these cases spread around the world, and it will be interesting to hear. I mean, we have Google being investigated in Brazil for multiple conducts, including the Android and others that they are investigating in Europe. And obviously this decision, now confirmed by the court, is something that will be raised in different jurisdictions around the world. Issues that Harold mentioned, exclusivity by dominant firms. We had a few cases going on involving delivery of food, involving gym platforms. One decision just this week in which the agency was very interested in exclusivity or most favored nation clauses and how those can limit entry and growth of potential competitors. I don't know if anyone else would like to comment on what they're seeing happening in their own jurisdictions at this point.
If nobody wants to comment right now, I wanted to share one thought which came to my mind. I mean, there are a lot of people are looking at these cases, a lot of money is involved, a lot of law firms write memos on it and have alert emails. But in the very end, the number of law firms or lawyers involved is quite limited. If you are representing Google or Qualcomm or one of the big 4 or 5 companies, then it's big business. But if you are not, I think it is relatively limited. So if a country introduces merger control, this might bring up, depending on the thresholds, much more business to a wider number of law firms than these abusive dominant cases in the digital area. So, I mean, when looking at the publications on it, you would get another impression.
Go ahead, John.
We cannot hear you, Jonathan. We can see you, but we cannot hear you.
Oh, Hannah, we can't hear you either.
Because I had muted the computer, but not the phone. You want to try reconnecting with your phone, or alternatively, you can drop your comment or question in the chat if you're having trouble with audio.
Yes, there is an issue with your microphone. Okay, so you write your comment in the chat. Very good.
Or in the meantime, anyone else? We know the Indian authority has been quite active in terms of launching also investigations, also in Turkey, also in Korea. So any comments and contributions there?
The German Federal Cartel Office made
Maybe Hi.
one or two decisions regarding the behavior of some digital companies in this very strange system, which I described in an earlier meeting, in that they now, in a first step, just found that these companies have a market dominating position, kind of, and then leaves it to further analysis whether they will then fine the companies based on infringements, which they have then to prove certainly in this fine decision. Very strange process. No fine decision yet. I'm curious to learn whether then this whole system will be under scrutiny by the courts or not. Sorry, Julia, go ahead.
Yeah, I was about to comment something, but completely different subject, but it's kind of new for us. Maybe you're all aware, but we just have the merger control regime since last year. We didn't have a merger control regime before last year, only for the electric sector. So it's something new for us, and there have been some advances in this year. We see that there have been already 17 notifications. 12 of them have been already authorized. And then we have 4 that are still in first phase, and just 1 that has gone to a second phase. This second phase is a public, and it's a laboratory merger. So yeah, that's like some advancements for our authority now.
So that's going to be mandatory notification if you meet the thresholds.
If you meet the economic thresholds,
that's a big change for the agency,
for
right?
all economic sectors. Before that, it was only for electric sector. So it's like everybody's learning how to make deals taking into account the antitrust authority. That was not an element before that. So yeah.
Will they also get foreign to foreign transactions if they have assets in Peru?
If they have assets in Peru and if the transaction has effects in Peru. Yeah. Yeah, so that's we of course we still have our cartel investigations and the litigation part, but the merger control team that is in charge of this is kind of new. So yeah, we are all learning. Yeah.
That's a good point for all of us to keep in mind. Dealing with
Yes.
international transactions is one more country to put on the map when you're
Exactly.
thinking of where to you need to file.
Yes.
Since we're talking about different developments in antitrust, not only in tech, but this is an interesting case for everyone to keep in mind. We just had yesterday in Brazil 6 companies admitting to participating in a violation involving the exchange of information in HR, in human resources areas. So this is a case that had been going on for a few months, started a while ago, but now we had, besides the immunity applicants, 6 other companies now coming, including Siemens, for instance, and Baxter, admitting to it, which obviously strengthens the case a lot. But it's an area where lots of agencies are looking at, HR. Many are dealing with no poaching agreements or looking at wage fixing. This is beyond that. This is exchange of information like benchmarking in HR, but dealing with sensitive variables like salaries and benefits in a very disaggregated, individualized manner. So this is a gigantic investigation with more than 40 companies, 115 executives being investigated. But now, obviously, with more people cooperating, they're strengthening the case. And that's something to keep in mind. Again, as agencies are looking at HR around the world, that's something it's a big development that will certainly incentivize the agency to look at those topics then.
Hi, everyone. Hi, Marcelo. And just to jump in with respect to that, are they from the same industry?
Yeah, they are all companies in the health area. They mostly medical equipment, but some of them are also in pharma. So they had a structured group of companies in the same area that discussed HR information and exchanged that. So yes, they were from the same sort of industry, even if they were not competitors amongst themselves. So they didn't sell the same products, but the idea is that they hired the same kind of people. So they're looking upstream at labor as a market rather than the sell side downstream.
Yeah, it's very interesting because HR has always been something like, at least in Chile, not expressly, but it's something like lawyers tend to put aside like it's something different regarding the exchange of information. And we know that in the US and other countries, this has been, so it's reaching us. So I think it's something that we need to put a lot of attention and be careful because to some extent, benchmarking studies are always done in that. So the analysis of are there competitors, is it the same industry, or the parameters for that investigation, it's very interesting because I think it's something that's gonna reach us soon.
And you're right, it's an important point to start training HR people in companies. Usually they are not included in compliance trainings, and
right.
And now it's one thing to start telling clients that they need to do that. And obviously having now companies who paid 34 million reais, we're talking about, I know, 6-7 million euro in total. They're not fines of the European Commission level, but they are significant fines, and individuals are also being fined. So that also helps us tell clients, you need to worry about these matters as well.
I'm not surprised that agreements between competitors on salaries are anti-competitive, but what I do not like is the tendency to go more and more for information exchange. Apparently, the competition authorities do not have enough cases with written cartel agreements, so they look into this in more detail. In Germany, this started about 10 or 15 years ago. There, information exchange was not an infringement per se, but the idea was if parties exchange competitively sensitive information, then there might be some more issues behind it, and they may agree. So this was more or less a proof of something worse. And then about 5 to 10 years ago, they started to infringe, to put fines on companies because on these infringements. This is very strange consequences. For example, what is competitively sensitive? Competitively sensitive, for example, is an agreement between car producers at which speed a convertible may open during running the roof, because this has an effect on customers. Customers would say, oh, I prefer the BMW better than the Mercedes, because when I'm driving a convertible BMW, I can open my roof whilst driving 60 kilometers and not just 50 with a Mercedes. But it's a competitively sensitive information. Last week, I got a call from a client. She is not only the head of Antitrust, but also the compliance officer. And her boss suggested to her to have a peer review regarding the compliance system. Now, at first sight, you say, okay, there are conferences on compliance issues, and at these compliance seminars, some heads of legal departments present their systems. Why the hell can't they not talk about it? But in the very end, the fact that you have a good compliance system may have competitive relevance, because then you are possibly in a better position to run your business in line with laws without fines. So in theory, you could even say that this is competitively relevant. And is this then a justification to say, well, it has a good purpose? The purpose is to make sure that companies are in line with laws. So I circulated an email amongst my partners whether somebody has come across a decision in which competitors are prohibited from exchanging details of their compliance systems in order to better run the business. Did somebody of you come across such discussion on a peer review regarding the compliance system and a possible infringement of competition law by doing this?
If I may say something, we done. Hello, I'm Irene from Spain.
Hi.
Hello, Harold, and hello, everyone. We did have a case in Spain. It doesn't regard compliance, exchange of views on compliance, but we did have a case where, and it's actually confirmed by the Supreme Court in Spain, where in light of a modification of the law applicable to distribution agreements in concerning petrol stations, one manager in one company sent a template agreement, just a template agreement to another competitor, just to help him do his job and to have an idea of how the agreement may be adapted to the new law. There was no commercial information whatsoever. There was not even the name of the petrol station, and also one of the parties was not, well, actually the agreement related to a particular petrol station, but it was hidden. That information was deleted, and the other company was not present in the same location where that petrol station was, and the company received a fine of 800,000 euro for that exchange.
Wow. Without any competitively sensitive information included.
No, and this has been confirmed by the Supreme Court. So
Wow.
it's pretty strict. And then there was another case which was parallel in time, where this is all public information. There was a number of car manufacturer, well, actually car importers into Spain, that in the middle of the economic crisis in 2008, 2012, just got together to exchange views on how the networks were developing, etc. And that there was no information on prices, no information on, it was only information on profitability by businesses, and also the numbers of dealers being closed and reopened. And that was considered a cartel information exchange, infringement by object, and confirmed also by the Spanish Supreme Court. So it's pretty strict over here, at least in regard to these two cases. And also, let me say, in relation to the no poach agreement, that we have a regional competition authority here in Barcelona that opened the case, this is also public, opened the case against an association of private schools, and is investigating a non-poach agreement within the association. So exciting things happening in Spain.
Can I jump in on that point? Is it possible for me? Yeah.
Sorry? I'm sorry.
Can I just jump in on that topic? So firstly, maybe I should introduce myself, because it's the first time for me to attend in this group's meeting. I'm Azar from Erginar, Turkey, probably the newest member of the group. I'm replacing Süleyman before, maybe you know before. I'm a senior associate responsible for competition law practice here. So I'm happy to see you all, and it's a very great pleasure for me to be here today. Regarding the HR investigations, it's probably the most popular topic in Turkey right now, because there are a bunch of investigations. And Nicholas's question was very relevant for Turkey, because none of the investigations had a sector limitation. So it means that if you are, you are somehow in any agreement with any company from any industry regarding a, no poaching agreement or that kind of things, you might be investigated in the same investigation, because HR is a very common thing. For instance, if you need an IT consultant, IT expert in a company from automotive sector, which is the same for the pharmaceutical sector, and you might find yourself within the same investigation. So there's no separation regarding a relevant product market, because the Turkish Competition Authority looks the case just like that. If you're competing for the same labor, let's say, for the same qualification of worker, that's enough to be in a cartel arrangement. And the authority is very aggressive. The most controversial topic here is whether the vertical arrangements regarding non-compete, no poaching obligations should also be included in that topic. So it was I know it was discussed in the US regarding whether they should apply per se legality rule or rule of reason analysis to vertical agreements, particularly regarding the franchising agreements. But in Turkey, the topic is more like, if you have any service relationship or vertical relationship with a service provider, can you just oblige the company to not to poach your employees? So the authority seems like they exclude the vertical agreements from the scope of no poaching agreements, anti-competitive no poaching agreements, but it's still a unknown question in Turkey, and this is the most popular topic probably right now. That's all from my side. Thank you.
Jonathan commented in writing on the decision of the decisions of the General Court. You can read it in the chat, and his conclusion is that when it comes to rebates, particularly exclusivity rebates and conditional rebates, this can have a strong impact on the daily advice you give to your clients if they are, as he nicely puts it, in a very comfortable position. Yes, sure, this is nothing which comes from the decision of the General Court. This is very old case law. Whenever your client is in a strong position, very comfortable position, then rebates are on top of your priority list.
I think Hemangini, you wanted to speak, yeah.
Yeah, no, hi everyone. Thank you. Just to introduce myself, I'm Hemangini. I'm with AZBN Partners, and just a few updates from this side of the ocean on some of the very topical discussions that we've had. So we don't really have a case yet on no poach, but a lot has been written about it. It hasn't really come up in the CCI's, the Competition Commission of India's radar yet. But interestingly, well, as of yesterday, the second most richest man in the country in his group, the Adanis and the Ambanis of the Reliance group, today it was reported, entered into a no-poach agreement. So this is the two biggest Indian conglomerates, and have a significant impact even in terms of sort of world businesses in petrochemicals and oil, primarily, but also telecommunication, increasingly, in airports. So they've entered into no-poach agreements, and it's going to be interesting to see if the CCI does anything about that. On the evidentiary threshold with respect to information exchange, Harold, very interesting. This has really been the subject of a many case law here. And it's interesting because the CCI at least has sort of gone up and down on where it finds information exchange to be actionable in and of itself. In at least one decision, the CCI found that there was information exchange. Parties had not acted on the information that had been exchanged, but were fined in any event. But not even 2 years before that decision, the CCI found that where information had been exchanged and parties had, because the parties had not acted on that information that was exchanged between the competitors, they let them off. And interestingly, that was in a leniency case. So we have, inconsistent almost jurisprudence on this point. It really depends on the facts of it. And frankly, at this point, slightly confusing, where we lie on information exchange. But I think the guidance has been that you need to be very careful if you're competitors and if you're exchanging any form of competitively sensitive information. And then just the final update, I'm sure many of you already know this, but the Indian Parliament almost, passed the Competition Amendment Bill. The Competition Amendment Bill sees some sweeping changes in the antitrust space in India, both in merger control as well as antitrust, actually. So we have the introduction of commitments and settlements, something that's already existing in the EU, but it's new here. In merger control, they're looking to introduce deal value thresholds. Which is by not a very significant sum, and this is primarily to catch your digital transactions in the digital market, which have low turnover or assets in this case, and so they're escaping scrutiny. So there is a strong push to introduce deal value thresholds. I think only Germany and Austria have deal value thresholds at this point. I know that America has it as well, but I think it's one of the many tests. Whereas the deal value threshold, if it's going to be introduced, is going to be the one that catches most transactions. So we'll certainly send through an update once this goes through, and it's maybe likely to come through even early next year. Winter session of the Parliament is going to see this through. So that was all. Thanks, everyone.
It's very interesting because the deal threshold idea, I mean, some countries are using that to be able to catch these other transactions. Others, like the US and we also in Brazil, the agency has the power to call any transaction that is not reportable according to the regular thresholds at any time. So they feel they don't need a value of transaction test. Because they can call, and they just did that with a WhatsApp transaction, for instance, that was qualified for mandatory filing, but they wanted to see it. So I think that's an interesting development that we're going to see more agencies sort of asking to see different transactions, even if they don't meet the tests, which adds obviously another complication for us when advising clients saying, oh, you don't need to file there, but we have to pay attention that maybe depending on the impact and how high profile a transaction is, you may be called in by the agency at some point.
No, absolutely, and that is, certainly a worrying trend. The lack of certainty as advisors and for business. And interestingly, the earlier version of the amendments that were introduced back in 2020 actually had that residuary power that gave the commission the authority to, not the commission, actually central government, to introduce any kind of thresholds to sort of catch. And so we're glad that this version has an deal value threshold, which at least lays down some test, as opposed to just leaving it open and catch any transaction on a post facto basis. But agreed, Marcel, I think we're still debating the pros and cons of even a deal value, but I think we're okay to live with that as opposed to what's happening everywhere else.
It could be worse. That's the thing.
It could be worse. Yeah.
All right, I guess, maybe I can take 3 minutes to introduce the update for China if there's no other jurisdictions want to speak. So actually, you probably know that in July, China has passed the new amendment to its anti-monopoly law since almost like 14 years. And then the new amendment to the law actually have, to some extent, relaxed some controls. For example, it intended to increase the threshold for merger filing, and it also introduced for the first time the safe harbor for some of the alleged those cartel and other so-called monopoly agreements. Interestingly, that the safe harbor rule was initially introduced to cover both the cartel and also the RPM, those vertical agreements. But in the final version, it is only intended to be applicable for the vertical agreement, but not for the horizontal agreements. While that on legislation that we have seen like an intention to relax control, but in practice, we actually have seen more a trend to strengthening the control on the violations, especially on the digital platform industries. So it remains to see that how there are still some implementing rules under the discussion, and we anticipate, for example, those thresholds for merger filing will be enacted before the end of the year. And also another trend we have seen is that China has strengthened its regulation of those anti-competition activities of Chinese local companies, while at least in terms of numbers of investigations, we have seen more and more investigations on domestic companies instead of international companies, unlike what happened in the past few years. So yeah, if there's any important update, especially on the merger filing threshold, we would be happy to send out an update for everyone.
Great. I think this has been a very interesting overview, flyby. Lots of things happening,
Yes.
Lots of things getting more strict, and how much that puts as a challenge for us in terms of advising clients to navigate. We try to be punctual in terms of ending so that everyone can know that they need to move on to their next appointment. So we're nearing the end. I think we'll just, I guess, very quickly, Harold, give them an update on the project of the merger control guidebook, and that they'll be receiving communications soon to update that. And then, and obviously for everyone, please feel free to send us suggestions for topics and things. That I think this is sort of resuming with a refreshed group. And it's been a great discussion. I think we can follow up on that in terms of focusing on some specific topics, again, getting people to participate. But it was great to hear everyone coming forward. So Harold, do you want to talk a bit about
I mean, the last version was from 2020, and I think we shouldn't wait that long, doing updates regularly, just asking the law firms to confirm that nothing has changed so that we are all updated. And we wanted to wait until the end of the holiday period, and we'll start this soon. by simply asking for confirmation that anything hasn't changed, and if something has changed, we would get updated versions.
We have seen just now that there have been some changes in some countries, so it'll
Yes.
be great to update it. And it's a project from our group. It's been going on for all. It's a great tool for us to use. First, it keeps us informed of what happens around the world, but also with clients, you can always show that you have the network that reaches around the world, and can provide that kind of support. So we'll be asking for your help in responding to those as the time comes.
There was a long discussion, and Hannah and Alicia, I think, or what is somebody else, prepared the old the old parts, the old chapters, so that we can send it to you, and that you can easily amend it, and we collect it and send it then to Hannah for putting it into the guide. I hope this can be done by simply replacing individual chapters rather than building it up from scrap, but we will see.
Perfect. Hannah, I don't know if you have any housekeeping messages at this point. No, otherwise
nothing else. Nothing else on my end. I think we've come right up to the 11 o'clock hour here in New York. So thank you.
Thank you all so much. We'll be in touch, and we'll again welcome any suggestions on topics that you want to discuss, and we'll have a maybe more focused conversation next time. But this was great, and it's great meeting many of you and welcoming you to our groups.